I entered this ChatGPT prompt relating to the new social media laws the government want to introduce. It went like this. The Australian government is looking to introduce laws that require people to prove their identity to access social media platforms. Many people will leave the platforms, and businesses relying on the platforms for customers will suffer. Is there a legal argument these businesses can use that would stop the laws being introduced? ChatGPT replied, there are several potential legal arguments that businesses could consider if they want to challenge laws requiring identity verification for social media access in Australia. While the specifics would depend on the exact wording of the proposed laws, here are some general arguments that could be explored. 1. Freedom of expression. Businesses could argue that mandatory identity verification infringes on the right to freedom of expression as protected under Australian law, including under the implied freedom of political communication derived from the Constitution. If access to social media platforms is limited, it could restrict participation in public discourse. 2. Unreasonable burden. If the laws create an unreasonable burden on users that leads to a significant drop in user engagement or participation, businesses could argue that this results in a violation of their rights to conduct business and communicate with customers effectively. They could claim that the laws disproportionately impact smaller businesses that rely heavily on social media for customer acquisition. 3. Discrimination or inequality. Businesses could consider whether the laws would disproportionately affect certain groups of people, creating an argument centered on discrimination. For instance, the requirement might disenfranchise those without access to identification or those less tech-savvy, leading to reduced market opportunities. 4. Impact on competition. Businesses could argue that mandatory identity verification laws could reduce competition by hindering small and medium enterprises that utilize social media for marketing and engagement. If the laws disproportionately affect these businesses, this could be framed as an anti-competitive practice. 5. Privacy concerns. Companies might argue that requiring identity verification raises significant privacy issues, potentially violating the Privacy Act 1988 and the Australian privacy principles, which govern the collection, use and disclosure of personal information. 6. Potential for judicial review. If the laws are enacted, businesses could potentially seek judicial review on the grounds that the laws were enacted without proper consideration of the impacts on businesses and the public, or that the laws are ultra-vires of the legislative body. 7. Economic impact. Proponents could argue that the broader economic impact of the laws, including job losses and business closures, may not be justifiable. They could mobilize data showing how reliant certain sectors are on social media for revenue generation. 8. International treaties and agreements. If the laws conflict with international treaties that Australia is a part of, such as human rights treaties, businesses might have a basis to argue that the government is not acting in accordance with its international obligations. Legal challenges can be complex and often hinge on interpretations of constitutionality, statutory law, and administrative law. Therefore, businesses considering this route should consult with legal professionals specializing in constitutional law, administrative law, and the relevant regulatory frameworks.